I'm going to pick up pretty much where Dana left off. And say again? That's opposite of the up button. I'm a very quick study. Let's just remember the general principle of what we're talking about, because we're going to be talking about issues and challenges that come in the administration of it, and let's keep the general principle in mind. The FMLA, until we get to the military side of it later this afternoon, but the FMLA provides 12 weeks of unpaid leave per year to an eligible employee based on a serious health condition of the employee or a qualified family member, not all family members, we've got to define family a little particularly, including return to work provisions. And then as the bottom bullet here says, we've got a recent inclusion of a bunch of military issues. That's going to be a separate discussion when we get into it later this afternoon. There are certain obligations that the employer must provide. The ones that we're most concerned with, Dana has already talked about 2 of them, but also don't forget you've got the general notice, the poster, where you put all your other posters, your EEOC, your FLSA, all these government-oriented posters. One of them is the FMLA poster. Don't forget that one. Where am I to aim this over there? I'm to aim it over there. The general notice is got to be conspicuous and posted on the premises. I'm not going to spend much time on that because that, I don't know, for $6.50, for $3.40, for some number, somebody sends those around you should be getting them now because the 2017 posters are being made available to you. So that's that poster. However, when we get to the specific notices, ones that you are to give specifically to an employee. Am I getting feedback? Apparently not. Okay. Let's talk a little bit more about the notice of eligibility and rights, because it can present some interesting questions. Surely you provide it, I'm backing up here. Surely you provide it whenever the leave is requested. But what about the situation where the employee does not request FMLA leave, but you know, or you have a reasonable suspicion, that the employee is eligible? Well, Tybo, when in the world would that ever happen? Keep in mind the definition, one of the definitions of serious health condition is when somebody is absent from work more than 3 consecutive days. So on the 4th day, when Bob calls in sick, what do you know? Come on, what do you know? This is a serious health condition. Aha! I might have an opportunity to impose FMLA. Start with the notice of eligibility. Dear Bob, I notice that you've been gone more than 3 days. You may have a serious health condition. So here it is. Fill it out, return it. One of the principles that we advise you to do as a general rule is that if you have a chance to use up the FMLA, use it. Because during the 12 weeks, as long as there's still 12 weeks left, all of the aces are in the employee's hand. But the day the 12th week is over, many of the aces return to the employer's hand. Not all of the aces, there's still a couple that are left. But if I've got 3 aces and a moment ago I had no aces, I feel like I have a better hand. So get that leave used up when you can. Going the wrong way. Let's a little bit more about the designation notice. This is the point in time when you've made a decision on the request or you're going to impose it, letting the employee know, by golly, we are, or we are not, approving this leave or counting it as FMLA. We are designating what's going on here. Maybe sometimes we say, you know, we don't know. We've not gotten enough information. We need more information. Those are generally in the situations where there's no doctor slip. Or maybe the doctor slip is ambiguous. Has anybody here ever experienced a fraudulent, well, I almost said fraudulent, a funny-looking doctor slip. You've heard of somebody who's done that. We've actually got an honest person here. Somebody actually submitted a funny-looking slip. It was actually fraudulent, be my guess. It's been known to happen. Have you ever heard of, you wonder why doctors' offices' return to work slips are numbered serially? Or the more careful, let me rephrase that, the more careful doctors' offices, their return to work slips are numbered serially. Otherwise, one of those things walking by just happens to fit right in my pocket, and whenever I or friends of mine need a doctor slip, we just might have one. Those things have value. $50 was the last I knew was the going price for an excused absence. Who here thinks that's not true? That's right. Okay, now why is getting these notices so important? Because the failure to provide the notice, now they say may. You and I both know when the government says that an employer may, what the government means is, by God, you better constitute interference, restraint, or denial of an employee's rights. And let me use different words. You just violated the law. So get these notices right. Where are we going now? The notice of eligibility. You got to deliver it when the leave is requested or within 5 days of having enough information, except in those cases where there might be extenuating circumstances. I know that there are a lot of examples where employees are excused from providing something because of an extenuating circumstance, and the most common of which is somebody slipped and fell on their way to work, and rather than being at work, they're at the emergency room. You know, that's I understand that. I haven't found the extenuating circumstance that would excuse an employer's timely fulfillment of its duties. I'm still looking for it. Keep calling. You might be the one who presents us with that, but right now, get it to them within 5 business days of when you've got enough information to make your decision. There are forms. Dana and I could have done a little bit better job of coordinating our presentations, but we figure if you get 2 copies of the forms, maybe you'll understand that this is an important document. So there are also copies of that form behind my presentation. Let's talk a little bit about the eligibility. If you decide that the employee is not eligible, you got to tell them why. I don't want to repeat too much of I don't want to repeat any of what Dana has said, but there are a couple things that, here is an important issue that came up since the last time we gathered. I have a Hispanic-speaking employee. Do I have to give them this notice in Spanish? And if I do, where in the world do I get it? And the answer is yes, you do, and I'm not sure. We ended up in that particular case calling the University of Toledo for a translation, and they happen to have them. I presume there are other resources where you might find in your particular language, because one of the things I'm noticing is that especially in the IT departments, we're not getting a bunch of, this is a really tender, sensitive season to be talking about ethnicity, and I don't mean to say it poorly, but maybe there are some Japanese or Asian folks in your IT department. They're not likely to speak Spanish. They may. My point isn't anything other than you've got to give it to them in a language that they're familiar with so that they can actually understand what you're saying. I can't imagine that we think that that's a remarkable obligation, but there are some employers out there in the cases that apparently thought it was rather remarkable. Question? Mark. The question is, what if you have an interpreter there? The interpreter does not satisfy the written notice requirements. Now, if the interpreter can translate it into writing and then hand the written notice, fine. The interpreter, we'll also come back to the interpreter later this afternoon when we talk about the duty to accommodate people. But did I repeat the question? I forgot if I repeated. The question was, what if there's an interpreter present? That's the question that goes with the answer. Let's get on to some other things. The designation notice. Again, these things that Dana has gone over. Here's something on the end, though, that is in the designation notice that more and more I've noticed we're just not doing. When we get to the end of the leave, we want to require a doctor's slip. Well, under the FMLA says you can require a doctor's slip that says nothing more than the employee is released to return to work. Nothing more. Comma, unless back at the designation notice stage, you check the box that says we're going to require a fitness for duty certificate, not just a return to work, but a fitness for duty with, and here's the job description or the list of essential functions of your position. The doctor slip must address each one of these requests, each one of these functions. But you only have the right to do that at the end of the leave if you have done this. Help me out. You are paying attention, yes, at the beginning of the leave. Everybody knew that, right? There's a certain person in the room who knows it especially well. Let's move on to some other issues outside the realm of the notices. Oh, I'm sorry. This is the last thing I want to get in with the designation notice. I've thrown up TTD there. For those of you, I think probably the whole room knows, that's an abbreviation from the world of workers' comp that stands for temporary total disability. By definition, when you've got an employee who's on temporary total, they have also got a serious health condition. And if you do not send them the designation notice, they are not on an FMLA leave. So we'll talk later about why it's good to do this or not, but if you want to run the leaves concurrently, workers' comp time off and a FMLA, do it at the front end. Do it at the designation notice. Okay, help me out here. Here's an interesting question that goes back to when the employee does not ask for the leave. Bob's been off 4 days in a row. Now you know that, and you go forward and you finish and you say to Bob, welcome back on after being gone 5 days for illness. We're designating those 5 days as FMLA. You've got 1 day remaining. Welcome to this world, Bob. And Bob objects. I didn't ask for FMLA. You can't do that. Well, yes, you can. Unless you live in the fair state far west. Anybody know who that state is? It begins with a C. California. There are some unusual rulings of all variety that come out of the state of California. And we'll just say that this is one of the more unusual ones. It says that I'm not going to tell you what it says because it's the only court in the world that has said it. My concern is that I think it's 2 of the last 5 Supreme Court nominees have come from where? Where will the next one come from? I'm not sure, but I'm just keeping my eyes on things that affect you. As we speak today in Ohio and Michigan, you can impose FMLA on an employee when they are otherwise eligible and the circumstances qualify. And let's let California be California for a little bit longer. Here is everybody's favorite. Don't we love intermittent leave? God, that's great. Jeez. Did you know that this is subtitled the Lawyers Full Employment Act? It's impossible to monitor this well, but we just do the best we can. The one thing I want you to know is that you can require them to use increments of time according to your policies, so long as you do not go down to a smaller unit than you use for other purposes in your employment. A lot of people, when you have an hourly employee, pay by the 10th of an hour. Well, 12 weeks of FMLA leave have now become 4,800 tenths of an hour. Anybody want to go back and sell insurance instead of being in HR? Sounds like an idea. Now, if you are, however, some employers go to quarters, every 15 minutes. Find whatever is your smallest unit of time for other employment purposes. And that's the smallest unit of time, provided it's no more than an hour. I've not met anybody yet who pays by the hour, who records time by the hour. It's usually the 10th or the quarter. But that is something to be alert to. Reduced schedule. That's pretty much what its title implies. It generally pops up in one of two ways. Either it's a part-time, somebody's gone from full-time to part-time, or they're going from less than 5 days to 3 days or 2 days. The schedule is what? Reduced. You see this frequently in work hardening. Somebody's been off a good 6 or 7 weeks, and rather than come back to a 40-hour week, they come back to 5 2-hour days. And then the next week, 5 4-hour days. And then the next week, 5 6-hour days. And then they're back. Well, on that 2-hour day, 6 hours is FMLA. In the 4-hour day, 4 hours. The unworked 4 hours are FMLA. Clear as mud? Good. I did want to back up. I did want to spend a moment on these examples of pre-approved use, because the one that seems to keep coming up the most is number 5. Well, they're not numbered on your sheet, but the migraine attack. If any of you have been here to any of these before, you know that at one point in time I had a secretary whose name was Sally, and God bless Sally, I mean this honestly, she is a magnificent person. She's retired from one of the best law firms in the area. Well, no, she's not. She's retired from the best law firm in the area, and I miss her, except for the migraines that she had. I'm blessed in many ways, one of them to which is I've never had a migraine headache, so I probably don't know what I'm talking about. That has never stopped me from talking anyway. Thud, come on. This is the event where maybe a moment before starting time, or maybe a half hour before starting time, you get the call that today's not going to work. And all I know in my experience with Sally is that it's not predictable. You don't know when it's going to come. It is intermittent. It comes when it comes, and it goes when it goes. And when you back it up with a valid doctor's certificate, it's covered by the FMLA, and you get to start knocking off those 4,800 tenths of an hour. The other one is happening more and more also, and that's the asthmatic flare-up of a minor child. Contrast that with the flu. I know, both from having been a parent and now being a grandparent, that elementary schools are really just breeding grounds for all variety of flus and influenza from about this time of the year till about this time again next year. You get over last year's school flu in late August, early September, in time to return to school and do it all over again. Asthma is, by definition, a serious health condition. So when the minor child has an asthmatic flare-up, it's covered. When a minor child has a flu on the first day, it's not yet a serious condition. You were all aware of that? I didn't think, okay, I should rephrase that. Was anybody aware of that? It can get you into the kinds of discussions that are very hard to have sometimes. Your child was ill. My heart breaks for you. What was he or she ill with? Those conversations tend to not be well received. You got to have them. How far behind am I now, Jackie? 49 seconds, 48, 47. Here is the other thing that we'll talk about on intermittent leave and wait for questions otherwise, and that is how can somebody's abusing this. You know, it seems that Sally, by the way, whenever I use Sally from now on, it's not my Sally, it's a made-up Sally, all right? Sally, it seems as though your migraines tend to come on Fridays and Mondays. I wonder why that is. And they tend to be the same Friday and Monday. And now if I go to the doctor's certificate and it says Sally's migraines are likely to occur on Fridays and Mondays, two things. Number one, she's doing it according to the certification. Number two, Sally's going to see a doctor I pick next time. That's not how migraines happen. Dave? I just didn't hear you. Oh, the question is, how do these kinds of discussions interact with HIPAA? The employee has the obligation to provide the employer the information the employer needs to administer the FMLA. And if the employee chooses not to provide the information by saying, I'm standing on my HIPAA rights, that's absolutely fine. Now, I, as the employer, have been denied the information I need to administer my FMLA, therefore I will deny your FMLA leave. Hobson's choice. Darn it, I hate to give up the floor, but I'm going to give it up. We will someday get to the end of the FMLA, or not. No, we want to hear about medical marijuana. I want to hear about medical marijuana.